their duty under the State Government Ethics Act to avoid conflicts of interest and appearance of conflict are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or appearance of conflict. So does anyone have a conflict that they need to disclose at this time? All right, if not, one other housekeeping thing, as mentioned a minute ago, I retired from the judicial branch after many years, August 31st. So emails are in transition. I have changed email address with most entities, including the state bar, but if you respond to an old email chain, it may go to my NC Courts address, which I don't have access to. So my email address that's included in the email Brian sent out this morning at 8 o'clock in anticipation of this meeting is correct. So I just throw that out in case anyone is trying to communicate with me on anything. All right, so our last meeting, as you will recall, was on June 29th, and Brian did a good job of the report on that meeting, which was submitted previously and was submitted at the July full ethics committee meeting. We sort of summarized that June meeting. I look back at my notes from that meeting this morning, and as I recall, we wanted to try to get some more clarity in the draft opinion on texting and communications with staff, trial court administrator, judicial assistant, so on, and then the simultaneous notification issue. That was something we had talked about. And then there are a couple other things. I think in my read of the draft, the revised draft, it looks like it touches on all of those items. So at this time, I will turn it over, since Brian and Carmen did the heavy lifting and drafting, turn it over to either one of them to talk about the revisions.
Sure, I'll take that unless you want to, Carmen.
I exhausted my ethics committee, bandwidth yesterday. So Brian, it's all you.
I was telling Carmen, yesterday was just but a taste of the fun that you can have when you work with the ethics committee, but for some reason she still likes dealing with the disciplinary stuff.
Yeah, I'll try cases. It's easier.
That's fair. All right, so I'm going to share my screen here so you guys can see we're all looking at the same document. This is the document that was sent out earlier today, although I will tell you I just made this change to include today's date here, but otherwise it's the exact same thing that was emailed out to you well a couple weeks ago as well as this morning. So yes, per Judge Rader's summary there, we're trying to just kind of finalize this potential opinion and what we're trying to hit on, all these different things about making sure that we're talking about text messages as well as phone calls and emails, because text messaging really has become such a main method of communication. But I kind of want to go through just what the changes are, just so we're all on the same page. You can see I track changes, so all the stuff that's in track changes was added after our last meeting. The first thing just to note was, and this is something that I think this committee needs to kind of, I guess, confirm that this is our desire. We had previously talked about how there are so many different ethics opinions out there. And the question that seems to come up, and I know it's been brought to my attention a number of times from a number of different sources, is we have old ethics opinions out there. Historically, we have not withdrawn those ethics opinions. We just have some kind of distinguishing language in the ethics opinion that says, to the extent that this opinion conflicts with an older opinion, that one is overruled. But I don't know that, particularly in this matter, where we have a body of opinions addressing communications with judges, if having that type of language would really clarify the situation for everyone. I think this may be a situation where we may want to withdraw those prior opinions, because it would, it leaves it, I guess having that language really leaves it open to the reader of saying, well, now I need to go read those other opinions and see exactly how this newest one overrules or addresses the things in the old one. And if the old one touches on something that the new one doesn't, then what exactly am I supposed to do with that guidance? And so I think it would be wise in this situation to recommend withdrawal of those prior opinions in favor of this one, because we're kind of trying to make this the new standing opinion on communicating with the judge, given the new, or I guess revised definition of ex parte communications under 3.5. So that's where this very first change is noted here. And I guess if I can just kind of ask, is that still the will of the subcommittee and the recommendation of the subcommittee?
Well, I'll throw in my 2 cents first for what it's worth. This issue came up a year or two ago, and I think at that time it was a different subcommittee. And at the full ethics committee, Alice brought up the same point that you brought up today, which is as a general rule, we don't withdraw those. We leave them there for historic reference, and they're overruled. And in the prior iteration of a draft opinion for this subcommittee, it made reference and said something to the effect of, where it's inconsistent, prior opinion is overruled. And that was one of the comments that we got back, was that it was hard for attorneys to understand that took a lot of work to go back and figure out where it is inconsistent with prior opinions. So, my vote would be to withdraw those prior opinions, because there's so many and they're so varied.
My recollection is exactly consistent with Judge Rader's. I recall that Jonathan McGirt, one of the family law bar's favorite flamethrowers, made exactly that point. And he gave thoughtful comments throughout, but he said, tell me which parts are overruled and which aren't. We kind of need to know that. So I think this opinion has enough moving parts that it would be wise to get down to one opinion.
I agree with all the thoughts that everybody shared. The whole intent, I think, of this opinion was putting in one very nice, clear, concise place all of these issues as they come up with modern technology, and what we can do, can't do, and leaving old opinions out there is going to leave room for interpretation.
All right. Well,
Jerry Collins here, Brian. And
yes, Gary.
To follow up, I agree with Missy and Judge Rader also, and Steve. If we've got this many prior opinions, it's going to be difficult for anybody to reconcile. And this is a huge topic, especially with family law attorneys. And I think family law attorneys really need to know what they can rely upon.
All right. Well, that's very helpful. I just want to make sure that everyone's aware that statement was going to be in the opinion, and ultimately, whenever we finish the opinion and we present it for consideration by the ethics committee, then the recommendation for publishing the opinion would need to be accompanied by kind of a corresponding motion to withdraw those prior opinions. So just procedurally speaking, we'll kind of have that on the table. The next part, I just want to again point out, this was something that was brought up in the last meeting, discussion of making it very clear that these considerations, the scenarios that we discussed in the opinion, all address situations where lawyer has opposing counsel, but oftentimes lawyer will be dealing with opposing party who's representing him or herself. And so we wanted to make it clear that this opinion applies to both situations, and if anything, I guess a lawyer needs to be that much more careful and more mindful of the potentials for ex parte communications in dealing with a situation where the opposing party is representing him or herself. So that's what this second paragraph here tries to address. Getting down, these were all the little things. I clearly there's a different.
Hey, Brian,
Yes,
I'm sorry. Before we go to inquiry 2, can I ask a question about inquiry 1?
sure.
This may be self-evident to everybody else, but when I read it again fresh this morning, and we were asking we were including an inquiry, can somebody file a motion to continue a hearing? I thought, well, that's the stupidest question I've ever heard. You know, do we really have to have an inquiry to tell lawyers that they can file motions to continue hearings? And I wonder if we shouldn't modify that inquiry, because where it says, may a lawyer file a motion with the court in County X? Are we talking about the clerk of court? Are we talking about the presiding judge? You know, if all we're talking about is, can a lawyer go down to the clerk's office and give the clerk for the record a written motion to continue a hearing, query whether we ought to include the words with the clerk of court in the county, so nobody misreads that to include the judge. That is, we're trying to distinguish between going to the judge's chambers and handing him or her a copy of a motion I'm filing, as opposed to going down to the clerk's office and having it file stamped in.
I think and I think you're raising a very great point. I think that the purpose of the first inquiry was to really set the foundation for what communications are really experienced in the practice of law with judges, what communications are allowed, because that was where we started talking about the framework of the opinion, referencing the different types of communications, the formal communications. Then there's the formal, there's the informal, there's the ex parte, and trying to kind of even to state the obvious of, yes, of course you can file something, you can use the normal official formal proceedings. That is the backbone of communicating with the court, with the tribunal. I'm wondering if maybe it needs to be more so that the inquiry is not so much may lawyer A file a motion, but the point that we're getting at is, may lawyer A communicate the scheduling conflict via a motion, which of course the answer is obviously yes, but it's, I guess to me, the answer being yes is not as much the point of the inquiry as the resulting analysis of setting out the foundation for what's supposed to constitute an ex parte communication, what is a permissible communication under the rules. So you're right that the inquiry is kind of self-evident, but I think it does serve a foundational purpose.
Well,
yeah, I think Mike's point is well taken, though, that it because it's such an obvious answer to an obvious question, it might make people think, am I missing something here? Like, why is the ethics committee telling me I can do something that of course I can do? So I wonder, I think it is important to articulate all of the virtues of formal communication, but it also might be possible to combine, inquiries. So really you are comparing and contrasting filing a motion with one of these other alternatives. That might be a way to avoid the issue that Mike was pointing out.
Yeah, or to put it another way, if what we're really talking about is filing it with the clerk of court, why don't we just say that? That is, may a lawyer file a motion to continue hearing with the clerk of court in County X? Because I am afraid, as Carmen said, that lawyers are going to think there's something else going on here. And by court, we mean you can walk it into the judge's chambers by yourself and give it to him or her and say, hey, just want you to know this is coming up and I'd really appreciate it being granted.
Yeah, I agree with that because we refer to the judge in an action as the court all the time. So that could cause some confusion. Further, to Carmen's point, is there language we can use to convince lawyers reading this that the bar isn't trying to trick them?
Right.
Can we say obviously yes?
Honestly, that was in my head just now. I mean, it does kind of seem a little non-traditional, but it kind of hammers home the point of, yes, there's nothing tricky here. This is exactly what you think it is. It's just setting up the rest of the opinion by contrasting the situation. I guess, Carmen, your point or your idea of combining this with another inquiry, I think we could potentially move some of this analysis into inquiry number 2 or the answer number 2 by kind of setting up in contrast, or the traditional method of communicating is through formal proceedings and so forth. So I don't know, I'd want to kind of take a stab at that outside of this call. And I could do that and just give you guys an option, email it out and see what you all think. Or we could go with what's on your screen right here.
Ryan, if you look up at the first paragraph on this page about lawyers communicate with judges on a daily basis, query whether the answer to inquiry number 1, whether we even need inquiry number 1. That is, you kind of fold that in to the first paragraph about, this is the backbone of an effective judicial system, the filing of formal motions that courts rule on, including motions to continue. Just think about that.
Yeah. All right. Well, if the subcommittee, if you all agree, then I'll take this kind of under consideration and see if I can relocate some of this analysis, whether it's in the introduction, as you said, Judge Robinson, or if it's combining with, another inquiry just to serve as a contrast, and send it out to you all and see what you think. If you like it, then we can go with that. But if we want to have an obvious first inquiry, if it just feels like it flows better, and kind of, explaining the context of just general communications with judges, then we can leave it with the obviously yes. But I'll take a stab at it and see if I can get you guys some options. All right. So then going on inquiry 2, there wasn't a significant change to this. This was just, we wanted to include by email or text message just to make it very clear that we're essentially talking about the same thing, some type of written communication that can be electronically provided, which raises the whole question of how exactly when does somebody get it, even if you hit send and supposedly all recipients are getting it at the same time. But again, there weren't a great deal of changes to inquiry number 2. 3, we had a similar situation, just very minimal changes. 4 is where we get to kind of I think a choice that the subcommittee needs to make, and I tried to outline it here by providing 2 options. And this was a result of Carmen and I were looking at this, and we were trying to draft a more complete answer, and we realized, well, maybe we have the answer as being yes, but maybe the answer is supposed to be no. This inquiry, of course, is the one that's asking, you've got a lawyer that needs to inform the court of their inability to attend a particular hearing. They want to informally request that the hearing be continued by email or text message to the presiding judge, but they copy the other lawyer They copy opposing counsel, which I think is probably getting to the heart of the issue that is prompting this this opinion, this practice that folks have of, well, as long as I just copy opposing counsel on my email, I have avoided an ex parte communication. But of course, our ex parte communication definition has been amended. So the whole question of simultaneous provision, which previously simultaneous provision exempted the communication from being ex parte and therefore prohibited, that's no longer in the rule. And so the first answer that we had was, essentially, yes, as long as this communication is not prohibited by law, local rules, or the presiding judge, and does not address the merits of the underlying case, that it really was just kind of an administrative communication, a scheduling communication. The reasoning was that, the rule now says that a communication is an ex parte communication if it's made in the absence of an opposing party. And the answer basically kind of incorporates some of the old reasoning there by saying that a communication to a judge that is simultaneously provided to opposing party and counsel is not made in the absence of the party, relying upon the general function of our electronic communications today. But of course, it goes on to say that essentially, these communications can nevertheless be prohibited by law or court order. And the presiding judge can give guidance or instruction to lawyers about such communications. Certainly if a judge says, if you have an administrative matter or a scheduling matter, and it's only that, you can shoot me a text message as long as you copy opposing counsel. That would be providing the notice that is now required, that's articulated for a definition of ex parte communication. But again, as Carmen and I were discussing it, we kind of realized, well, maybe the answer really is supposed to be no under this new definition of ex parte communication. So I essentially gave you two options for answers. Again, the first one was yes, but this one, the second option would be no, that essentially no, an attorney cannot just send an email or a text message to the presiding judge with a copy to opposing party or opposing counsel, even if it's about an administrative matter, that those are just simply and strictly prohibited without or unless the court expressly authorizes it. And of course, the reasoning here for option two is that this sending of an email or a text message, that it should be, or something that if it's sent in the absence of the opposing party, then it's going to be ex parte. And just the kind of the reality of these electronic communications is that while you may send it to both recipients at the same time, there's no guarantee that they receive it at the same time. One person may be, whether it's the judge or whether it's opposing party, they may, particularly if the judge is sitting there and the judge sees the email, but opposing party is in a client consultation, is in another hearing, or is just doing something else that ultimately prohibits them from picking up their phone and seeing, what was that alert truly about. And so maybe that is really kind of I think option number two addresses more of the reality that people don't receive those electronic messages at the same time. And so therefore, maybe they are actually made in the absence of an opposing party and should be prohibited. So with that said, open it up to the floor here. I'd love to hear the subcommittee's thoughts on these two options and if you feel one is more correct than the other.
So, Brian?
Yes, sir.
In the 30th Judicial District, which is also known as the 43rd Prosecutorial District, the tradition for maybe 15 years for the district court judges for their calendars has been to invite. And it's a little bit more of an invitation, because if you don't respond by email as to the scheduling issues that you may have with the calendar, you might receive some degree of punishment. but is to invite the attorneys to respond to the calendar, to inform the court of any motions to continue, specifically of any motions to continue, as well as any other scheduling conflicts the attorneys may have. And I can say that option number 2, and I know that our district court judges and our chief judge, Rick Walker, and I'm sure Judge Rader knows, but they can speak for themselves and on this kind of an issue much better than I can. But this option number 2 would wreak havoc on our current practice as it occurs. Having said that, let me give you a real life example of why option 2 could be good. And that's because I had a Sunday night communication that an opposing attorney had with a judge at 7:30, 8 o'clock p.m. By email, which I discovered at 6:30 the following morning. And I was a little bit unhappy with that. But that was about a scheduling matter. But I don't know that there's a pill that we can prescribe that cures all those maladies. And to me, option number 1 is probably as a practical matter, is a thing that allows the wheels of justice to turn and allows work to get done. Because the attorneys of my district are very comfortable right now in the real world practice of law, operating under option 1.
Great. Thank you, Jerry. Jerry, can I ask you, do you think this, I guess with what you just described, do you think that the language in here that essentially says, unless the communication is authorized by the presiding judge, then do you think that, or even if there's a local rule or something like that that's adopted, would that cure the concern such that essentially your district could continue to operate as it is comfortable in operating? Or do you think this would still cause that much more confusion?
I do think it could and would cure that if it was done as a formal local rule. If the state bar had some ability to oversee that, but if the chief district court judge or resident superior court judge, if they didn't make it part of their local rules, I think we've left in a way the attorneys in limbo, and it's going to leave some poor lawyer in front of the grievance committee trying to defend on the basis that it seemed to be an implied rule in a matter of practice. And I don't know that's a good thing to do either. But I will say, I agree with you that if it was a formal rule that had been adopted as a local rule, it certainly would solve that problem.
Just on the issue of dragging poor lawyers before the grievance committee, since that's my area of expertise. Well, first of all, I would say that if such an allegation were made under the rule, and the lawyer's response was, "This is how we always do it," and that was verified, I think I would no longer have any concern about a rule violation. But I wonder also that whether we could incorporate local customs of practice, because that we actually have reference to that in another rule. I'm trying to remember what, maybe 3.5.
Yeah, it's under 3.5.
So I mean, it actually goes beyond codified local rules to say, we're acknowledging the existence of local customs of practice. So that would also would be another type of language we might be able to incorporate to make clear that this ethics opinion is not trying to undo a process that works in the communities.
I'm curious to hear, Steve, Missy, what are your I guess, what are your local customs? You know, or is this something that is this type of communication of the email or the text message being sent with a copy to opposing counsel, is that accepted and welcomed, or is that something that's happening and people are continually getting upset with each other and getting in fights over it and it needs to stop? I mean, I think that's why, you know, option 1 and 2, they reach different results, and we want to make it consistent with the rules, but also consistent with practice. You know, we don't want to change the practice necessarily. So what are your thoughts there?
I will say one of the things I have learned being on the ethics committee is that lawyers in criminal cases really don't seem, the things that we fight about are usually case related. I honestly don't see somebody getting all twisted around over, you know, an email at 8 p.m. at night that says my kid is sick, I'm going to have to reschedule tomorrow's hearing that goes to the judge. And you know, I think that those aren't things that we get all worked up about. I understand family law matters are going to have, you know, it's urgent issues dealing with people's clients and custody and their kids and all that stuff. So I do defer somewhat to their judgment. My preference in this is option 1, because I do think with option 2, the difference is it's going to be subjective, that some people are going to say, oh, I thought this judge was always good with us doing this way. And you're going to have somebody who says, no, the judge didn't expressly say. I mean, I think I look at option 2 and is that going to mean that local rules have to get implemented? Is it going to be that what if judges want to have different standing orders in certain counties about how this is done? You know, I think it's important that I also think it's important that we are abiding by the rules, but also not making things more inefficient than they need to be. And I think option 1 covers it in giving guidance with limitation in terms of what can be done. And if you violate that limitation, that's fine. But I think option 2, the rule followers are going to be extra big sticklers about it. And the non-rule followers are always going to say, oh, I had a case with this judge 4 years ago and they had always told us we could do this. It's, you know, that it's going to just leave murkiness.
Yeah. Thank you. Steve. Oh, Steve, I think you're muted.
Yeah, just to use Jerry's hypothetical, I would, and what Missy says, yeah, Jerry's not wrapped around the axle over this, but he's not happy. Maybe he spent 4 hours all Sunday afternoon prepping for the hearing, and you know, he's just, it's the next morning, or maybe he spent 4 hours after the message was sent and didn't see it. That's even the better example. But so I've been annoyed at these kinds of things, and I worry about younger lawyers are more text centric. You know, I have an assistant who thinks the phone weighs 400 pounds, but to make a phone call, but to send a text message, it's, you know, all day. And so this makes me cautious about Carmen's suggestion that we use, you know, common practice, because people have different views of what that might be. For younger lawyers, it might be, yeah, everybody communicates with a judge by text. I never have. So I'd be worried about that. I mean, 1 tells us yes, but, you know, however, be careful. And 2 tells us no, but, no, but, however the exception begins accordingly. So I don't know. I'm comfortable really with either. I probably would tend more toward 2, that, you know, I'm concerned that the communication doesn't get to both parties at the same time. And of course, the first best thing to do is get a hold of opposing counsel. And we say that elsewhere. So those are my thoughts. I could go either way. Also, one housekeeping thing on the inquiry, we've changed via email or text message, but we just say be copied on the email. Probably should say or text message at the tail end of the inquiry.
At the tail end of
The inquiry itself.
Ah, yes. Thank you.
But I think it's a good, I think I'm comfortable with that opinion either way. Have there been prosecutions on this kind of thing, Carmen?
The only cases that are coming to my mind were instances in which the simultaneous copy wasn't really the issue. It was about the content of the ex parte communications. It was the other piece about, because as Ryan said, under the former rule, the former rule simultaneously provided, CC'd electronic communications were not considered ex parte. And so really it was all about, well, yeah, but if you send the Sunday night email and what you're doing is arguing the case that's going to be heard Monday morning, then there's a problem. And that's the only disciplinary thing that I recall really on electronic communications.
Carolyn, what do you think? Do you have any perspective from the bench, from the Code of Judicial Conduct, and things that you've advised judges on or taken calls on?
Sure. And just as a disclaimer, I give lots of advice. That doesn't mean the commission, if it was informal advice to judges, that's not the same thing as when the commission gets a complaint and reviews it. They collectively may see things differently. I will tell you, I do see quite a bit of, I don't get asked for advice on this a lot, but I do see a lot of complaints by the litigants that their cases are continued. And they don't like the fact that, they want their cases heard. So we really look, when we deal with these continuance issues, what the code is really looking for, in addition to the ex parte communication aspect, is this delaying the administration of justice because the attorneys are not able to move it forward and the judge has been too lenient in letting them kick the case down the road at the expense of the clients who are paying attorneys' fees and getting the disposition of their cases delayed. So there's a couple of concerns from the judicial side that we look at with continuances, not just the ex parte communication, but the actual impact on the administration of justice. In terms of these informal ones, I will tell you, we just had a commission meeting this morning, and one of them did involve a complaint by an attorney about the judge communicating with opposing counsel. The commission tends to not, I think I've discussed this in the last few meetings, in terms of administrative matters, the commission doesn't get as agitated as it would be if the judge was communicating on the substance of the case or something that was going to get to the merits. So I don't think they tend to focus on that because they do get complaints of a much higher magnitude that are concerning to them. The thing that is bothersome to me, and looking at inquiry number 4, is it does seem that some judges do have some issues with the commission where they initiate a text to the lawyer, like, where are you? Why aren't you here? And then and this is while the judge is on the bench a lot of times. And so you've got one attorney in the courtroom and then the judge on the bench communicating by phone with the other counsel. And so, you mentioned here, would lawyer B copied on the email or the text? Well, what about if lawyer B is standing in the courtroom and can't really hear what they're talking about? And that is something that's these communications between just the judge and the attorney are concerning, because they open the door to all kinds of other communications. So between these two options for inquiry 4 and option 1 and option 2, I think you could really combine them and say, may lawyer A inform the court of the inability to attend and copy lawyer B, we would want to minimize all of those emails and texts to the judge on scheduling issues that should appropriately could go through the court to communicate with the judge. So I kind of liked the idea of option 2 of no, unless the court law or local rule authorized such communications. That way each court could, the default is judges don't text or email the judge unless the local court has established something by rule or order that sets up a protocol for doing it. So if that makes sense. So the default is no, unless the court does something to allow it. And I kind of prefer that because to me, option 1 just opens the door to more and more texts and phone numbers being exchanged, and that I could just see leading to problems, because once the judge has the lawyer's phone number, then the temptation is the judge just to just reach out to that person at all different hours. So that's sort of my sensitivity to it.
Thank you. Well, it sounds like there's kind of reason for both. I think that as far as a vote is concerned, we're kind of a little split. Judge Rader, you have some thoughts?
Yes, when you read through it, you read option 1, you think, yeah, that makes sense. Then you read option 2, yeah, that makes sense. So you do get a little confused on which is more appropriate. I tend to agree, I think, with Carolyn's analysis. And when I looked at this, I think of an ex parte communication. You got to have, in absence of the opposing party, that means it's ex parte unless you let them know. It doesn't matter how, just you let them know. Then you also have that element of without notice to the party. And notice to me means a little more than copying them simultaneously. And that raises the, endless question of what is adequate notice. But I think notice, the idea behind notice is giving someone advance notice or prior notice so they have an opportunity to make an informed decision and respond. This idea of sending it to them the same time I send it to the judge, and then whenever they get it, I'm covered because I sent it to them. And if I looked at the comments to 3.5, comment 8, it says, for example, a lawyer should not communicate with a tribunal by writing unless a copy thereof is promptly delivered to opposing counsel or to the adverse party if unrepresented. It goes on to say, ordinarily, an oral communication by a lawyer with a judge or hearing officer should be made only upon adequate notice to opposing counsel. I'm not sure if there's any difference between oral, well, there is obviously a difference between oral and written communication, but I think they're both ultimately could have the same effect. And that comment inserts the word adequate. And I wish the rule had the word adequate or advance or prior notice as opposed to just notice. But for that reason, I tend to think option 2 makes more sense. And with respect to the issue that Jerry was talking about, I think that is more in line with invited conduct or behavior. If the court expects you or has requested that you communicate by email, that's a different issue. So, I think I would go about it if I were drafting it, I would probably go, as Carolyn suggested, option 2, no, and then maybe have a scenario where it would work. But the last paragraph in there where it says one cure for this scenario, absent authorization by the presiding judge, would be for the lawyer to provide reasonable notice to opposing counsel of the need and intention to send the communication to the judge. I think that is at the heart of what we are trying to convey, is that you should use due diligence and you should make a good faith effort to contact the lawyer before communicating directly with the judge. That's kind of my thought.
And if you don't mind, I just wanted to add on to what Judge Rader was saying, because it's been a long time since I practiced law, so let's bear that in mind. But to me, the preferred way to keep the judge out of trouble is the requirement, and I practiced in New York and down here for a while, but that you had to, in making a request for a continuance, you had to notify the judge that you have consulted with opposing counsel and what their whether they agreed or opposed it. And that certainly would make it a lot easier for the judge to know if they're wading into some kind of thicket with these things. And, the judge shouldn't rule on the request for a continuance without hearing from the other side. So I concur with Judge Rader there on that last paragraph. I almost feel like that should be the rule. Don't make an informal request unless you first consulted with opposing counsel. And then if you have, you must communicate X, Y, and Z. But I do think that last part is very important and should be emphasized for lawyers. So.
Brian, let me follow up on that as well, just to say amen and to note two things or three things. One, on the 8th and 9th lines of the proposed option 2, it references the reality that the so-called simultaneous provision of communication by way of copying opposing counsel does not result in simultaneous receipt of the communication. I assume the inference there is that the judge is going to get it before the opposing counsel. And Judge Rader can, correct me from his experience, his much longer experience than mine. But trust me, I'm not sitting at my desk waiting for emails at 9 o'clock on Sunday night, by people who have problems with scheduling matters. It's just as likely that opposing counsel will see it before I do. But I think the point is well taken. That is, the goal is that opposing counsel ought to have prior notice before the judge is notified, and only in true emergencies should the communication be simultaneous, unless there's no way to avoid it. We later, in one of the later inquiries, talk about somebody has a wreck on the way to court. That's a fairly unusual situation. I've had it happen, and I'm sure Judge Rader has too, but it's not, an everyday thing. And generally people don't get mad about that if somebody's in a car wreck on the way to court. But what they do get mad about is, as I think Carolyn pointed out, and Jerry pointed out, somebody knows at 5 p.m. on Sunday that they've got a real problem, and they wait until 9 o'clock and they email the judge and opposing counsel at the same time. As a result, at least in the business court, we have a standing rule that before you ask for a continuance, you must first communicate with opposing counsel or the opposing pro se party, and you must report in your communication with the court what the opposing party's position is. A, do they consent? And B, if not, do they wish to be heard before the court rules? And I think that, goes a long way to keep people from using continuances as a strategic mechanism, which I think Marcy was, pretty agitated about. And I get it. In the family law section, there's a feeling sometimes that requests for continuances are used for strategic purposes. I get that concern. So I wonder if we should consider redoing the language in the 8th and 9th lines of this option 2. And I would change the word cure to solution, because it's not an illness, but it is a problem. But I would, that's a long-winded way of saying, I think probably option 2, at least from my vantage point, is the better option at this point. Thanks.
All right. Well, I will thank you everybody for your comments. I think this is very helpful. It sounds like we have I guess a preference for option 2, although it's a I understand Missy's point and Jerry's points.
Don't let anybody get heartburn over my, I was really close between the two. I'm fine with that. Listening to all the wise words that everybody else has had to say, I'm good with 2.
Yeah.
And
I agree
Brian,
with Missy on that. I'm sorry. Go ahead, Jay.
go ahead, Jerry.
No, go ahead.
Well, I was just going to say, I hate Marcy's not on the call, but I think it would probably be worth, after the fact, reaching out to Marcy, because she, being a family law practitioner exclusively and having pretty strong feelings about this in the past, I think her input might be valuable.
Right.
And I agree with Missy. I'm not wedded to option 1 either. And as Ryan suggested, for our judicial district, the simple solution would be for the chief district judge to just simply make an amendment to the local rules that allows for the way that they're doing their calendar.
Right.
And actually, I can actually work with them on that if that's the way that they wanted to go. And they may like option 2 so much that they change the way they do their calendar.
Okay. All right. Well, I will. I'll take that into consideration when I circulate another draft based upon what we've been talking about today. I know we're approaching the hour mark. So Judge Rader, if it's okay, I'm just going to kind of explain these last parts, and I guess maybe if we want to have another meeting to discuss this before the October meeting, we can set that up. I think it sounds like the subcommittee would prefer to be able to introduce this to the ethics committee or present it to the ethics committee. So the inquiry number 5, kind of plays off of the prior inquiry. It basically has this question: can lawyer A communicate his inability to attend the hearing informally, or informally request a continuance by email or text message, with lawyer B copied on the email or text message if that email or text message contains additional argument on the matter to be heard? And of course, the first answer was no. We would need to potentially change the inquiry if we go with option 2 to basically kind of articulate that lawyer A is now giving proper notice to lawyer B, because that's the only way under option 2 that lawyer would be able to send this communication without it being ex parte. And that's the scenario we were trying to set up in inquiry number 5, that the lawyer is complying with the ex parte communication, or I guess I should say is not engaging in ex parte communication, but is still getting to the merits of the underlying issue. And of course, the answer still remains no. But it really just kind of, I'd say that the tweak here was noting the notice that's been provided now by the lawyer to take it out of the realm of ex parte communication, and really just say that regardless of the fact that this is no longer an ex parte communication, it still violates the rules in that it's prejudicial to the administration of justice to engage in some sort of discussion or argument about the merits of the case in a forum that's really outside of the ordinary course of the formal proceedings, and certainly in one that has not been invited by the court. So that's where the changes are here. It's just kind of a tweak to what we had before. Number 6 is where we were, we talked about the emergency situation. Lawyer A is scheduled to appear in court, gets in a significant car accident, unable to attend the hearing. Can they contact the clerk's office or trial court administrator without contacting opposing counsel? and informed of the inability to attend the hearing. And the answer that we drafted was yes, that essentially the rules are supposed to be rules of reason. And certainly a lawyer should always try to provide notice to opposing counsel, but because the rules are rules of reason and the reality of emergencies can limit a lawyer's ability to notify opposing counsel, then this inquiry really is trying to kind of guide the lawyer to contact not necessarily the presiding judge, but maybe to contact the TCA or the clerk, so that that person can inform, at least hopefully inform the judge and opposing counsel at the same time if they are communicating this sudden absence during a calendar call or what have you, but that just, essentially not trying to so strictly follow the term that that these communications cannot occur in the absence of opposing party. That, in the absence of opposing party, yes, the TCA may go and tell the court, or may tell the judge, and they don't get to immediately communicate that to opposing counsel or what have you, but that it's reasonable enough in time to receive that message, that it wouldn't necessarily constitute an improper ex parte communication. So I know we talked about this at the last meeting. I'd be curious to hear if everybody thought that this inquiry and the answer captured what you all were intending.
Well, I'll jump in first, if only to say, if you ask, in my humble opinion, if you ask 100 practicing trial lawyers whether calling the TCA would be reasonably expected to result in the judge and opposing counsel being informed of the problem at the same time, 99 of them would say no, that what they would expect is that the TCA is first going to tell the judge what's going on, and then would expect the judge to instruct him or her what to do about it. So if we want to permit this because it's a true emergency, I get that. But I don't think we should include the last sentence about it being calling the TCA is a manner of communication that is expected to result in opposing counsel and the judge to learn the information at the same time. That's just not the way it works, in my experience.
I want to second that and say that I don't think, given this hypothetical, this communication has to be simultaneously made to court and opposing counsel. Emergency is an emergency, but if you can communicate with the TCA and or the clerk or the judge or anybody else, you can also copy opposing counsel.
I agree.
Agree.
So just to clarify, are you saying that we should rewrite the answer to say that it's that basically you can contact the TCA, but you must also simultaneously copy opposing counsel?
Yes.
Okay.
I mean, I would say yes, but the lawyer needs to communicate with both the presiding judge and counsel about the scheduling matter. Well, it wouldn't belong there, but somewhere.
Right.
This is an instance where simultaneous without notice would be reasonable, but court alone without notice, not hardly ever really reasonable. And, again, if you're in a coma, then nobody's going to get a communication, or somebody will hear from your wife, or husband, but yeah.
Okay. I will
maybe one solution, Brian, is to, put language in there that says, in a true emergency, counsel can communicate with the trial court administrator to advise the court of their situation, but should make good faith efforts to communicate and notify opposing counsel or the opposing pro se party as well.
Simultaneously.
Well, if you're making a phone call, I don't know how you do that simultaneously. I guess you try and do a conference call. I mean, if you're in a wreck and you're hurt and you're being loaded in the ambulance, who are you going to call?
I take your point, Mike. I was thinking in terms of a text message. But a phone call.
Agreed. No, I couldn't agree more. Electronic communication like email and text in an emergency, everybody who can be copied ought to be, but this envisions, I think, a lawyer.
Yeah, I just put
Go into the inquiry by, are we talking about a phone call or are we talking about a text message or an email?
Well, and that's why I left it as the vague, just contacting the
Okay.
clerk's office, because I think the same rule, I think it'd be kind of difficult to apply two different rules depending upon the method of communication, telephone or text message. I don't know if we wanted to actually create two different things so that a lawyer in an emergency has to think, well, if I'm going to send a text message, I need to do this. If I'm going to call, well, I just can't call, or I could do that under these circumstances. And so I just left it as kind of the nebulous contact to try to basically say that this is an emergency, rules of reason, and to try to take it out of the ex parte communication definition. But I think there's some, there's just some rewriting that needs to occur based upon, I guess just the reality of that. I see exactly what you're saying and I agree with you. So I'll take another stab at that and circulate. Judge Rader, I know we are at the hour. And I guess that's what we had for the inquiry number 7, lawyer contacting judge without contacting the opposing counsel about the emergency. We said no, that essentially the TCA contact, but the judge, no, just like what you said, Steve, it's never going to be really, it's hard to say that's ever going to be reasonable to contact the judge without contacting opposing counsel, but you could contact court staff, essentially court administrative personnel. So with that said, Judge Rader, I think there's some redrafting that I can do and try to get you all a new version, try to turn this around fairly quickly so we can meet again before the October meeting, if that'd be your preference.
I think that's what we should shoot for. I really, really, really feel like as long as this issue has been around, we need to try to get a draft opinion to the full ethics committee in October. So okay. I think we need to shoot for that.
Agreed.
And I do think we need to reach out to Marcy before you redraft.
I will do that. I'll contact Marcy and I'll get back to you all. My goal is going to be to have a new draft to you all within the week, and perhaps and the same communication, ask for your availability sometime maybe in the first week of October, last week of September, something like that. Just kind of see where we're at and if we can get together and review that last draft.
That sounds good. Brian, thanks to you and Carmen for your work on this, and thanks to all the members for taking time on a Friday afternoon to participate. Okay.
Judge Ray, thank you all.
Anything else?
Thank you, everyone.
All right. Thanks.
Have a good weekend.